Jessica Thompson for the department.
Alfredo Padilla on behalf of the mother, Judge.
Alexandra Vanderbilt, investigation supervisor.
Bonnie Jones, investigator.
Jennifer Harris, attorney ad litem for the children.
Rochelle Acevedo for Mr. Trevino. Mr. Trevino, can you please announce?
Yes, I'm Michael Trevino, the father of Alexis and Michael, Anthony, and Maylene.
Yes, I am the mother of Alexis, Michael, Anthony, and Maylene. April Rendon.
Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You can put your hands down. Okay, Ms. Thompson, do you have the terms and conditions of the agreement?
No, I do not, Your Honor.
Okay. Does somebody know what they are?
Judge, it was my understanding we would stipulate to the TMC without stipulating to the accusations and the affidavit, but the Rendon's willing to do services. I'm sure he is.
Okay.
I worked it out with this Emily Keller Green, Judge.
Yes, I understand. She's
Okay.
just, I'm going to mute you, Ms. Rendon, because I hear all the traffic there around the courthouse. Okay, so Ms. Thompson, that's your understanding of the agreement is TMC to the department, the parents to be temporary possessory conservators, a 262013 caveat that the parents don't agree to the allegations, and then parties will set up an FGC for the parents to do services.
Correct, Your Honor.
All right, is that your understanding of the agreement as well, Mr. Padilla?
Yes, Your Honor.
All right, Ms. Acevedo?
That is my understanding, Judge. I think the only thing that we didn't negotiate was visitations.
Okay. Ms. Harris, is that your understanding of the agreement?
That's my understanding, Your Honor.
Okay. Well, typically the visitation starts at, two visitations for an hour supervised a month. We've got a 2-year-old. I don't know. What are you thinking, Ms. Harris?
I think that that's probably appropriate. I would just, summer's coming, so we'll be able to work with schedules and all of that coming up. But until then, if there's any school or preschool or anything like that, I just wouldn't want it to interfere.
All right.
Would the court consider 2 hours instead of 1 hour, Judge?
Well, what we probably would do is I'll start with the standard and then would give the parties the opportunity to increase visits based on the engagement and appropriateness of the parents without having to come back to court. I don't know if there's 4 children, so I can certainly understand how an hour may not be long enough. I can understand that, especially with the ages of the children. I can make it kind of clear on the record that if the parents are engaging and things are going well, that it is probably appropriate to look at more than just an hour every other week. I don't know if that would be an hour a week or 2 hours every other week, but with 4 children of this age group, it's going to be tight for an hour for the parents to give attention to both of the kids. So are the parents going to be visiting together? Are they a couple, Mr. Padilla?
Yes, Your Honor.
Okay. All right.
In that case, Your Honor, I have no problem with it being 2 hours, 2 times a month.
Yeah, I think that's a good starting point. And then I can give that authorization for more to happen if we need to. Okay. Ms. Rendon, you heard the agreement and that's your agreement?
Yes, sir.
And you had a chance to discuss that with Mr. Padilla?
Yes.
And you understand what the agreement entitles you to and you understand what it obligates you to?
Yes.
Were you forced in any way to agree to it?
No, sir.
Did anybody make you any promises or inducements to get you to agree to it?
No.
All right. Mr. Padilla, does your client enter an appearance today for all intents in this case?
Yes, Your Honor, I thought there was some problem with service, but that's fine.
Okay, I don't, we didn't have a return, but either way, we got that covered. Okay, Mr. Trevino, did you hear the agreement that was stated on the record?
Yeah, yes, I was told and I agreed with the services.
Okay, and you weren't forced into any of this, you're agreeing to it voluntarily?
No, I wasn't. I agreed voluntarily and you know, just gonna agree with on the, because I had told her I was gonna agree with the services and everything.
Okay. All right, Ms. Acevedo, does your client enter an appearance in this case?
Yes, Your Honor.
Okay. Then the court will find that both parents have appeared today and entered an appearance in this case. The court finds that the agreement of the parties is in the best interest of the children. The court finds that well, actually, let me stop and back up just a little bit. Ms. Jones, could you unmute for me, please?
Yes, sir.
Do you believe that this agreement is in the best interest of the children?
Yes, Your Honor.
And do you believe that it's necessary to protect the children?
Yes, Your Honor.
All right. You believe that there was a, now, I know that the parties have agreed that the parents don't concede to the allegations, but notwithstanding that, do you believe that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home was contrary to the welfare of the child?
Yes, Your Honor.
Do you believe that the urgent need for protection required the immediate removal of the child and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the removal?
Yes, Your Honor.
And do you believe that reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home?
Yes, Your Honor.
All right. Just briefly for me on the record, state what reasonable efforts were made to prevent a removal and what reasonable efforts were made to return the children home.
We attempted to get a safety plan in place. We attempted to establish a parent-child safety placement, and we're unsuccessful on all attempts with parents.
All right. So it's your testimony that there was no other alternative other than to remove.
Yes, Your Honor.
Okay. And you believe this agreement, well, I think I already asked you that. You believe this agreement's in the best interest of the children?
Yes, Your Honor.
Okay. Then the court will find that the agreement is in the best interest of the children, and I'll make the standard findings based on the questions I just asked Ms. Jones under 262-201 G1, 2, and 3. I'm not going to repeat them all on the record. Just make sure they're in the order, please. Court will find that it's in the best interest of the children to name the Department of Family and Protective Services and the SSCC as the temporary managing conservator of the children, Anthony, Maylene, Michael, and Alexis Trevino, and the court will name the parents, Ms. April Rendon and Mr. Michael Trevino, as temporary possessory conservators of the children. Court makes a findings under 262.013 of the Texas Family Code that by their agreement, the parents do not concede to the obligations in the affidavit. Court finds that the reasonable efforts have been met according to the statute as stated in the testimony of Ms. Jones, as well as the information in the affidavit. Court orders the parties to participate in a family group conference to develop family plans of service that are narrowly tailored to address the concerns that brought the children into care. And the court will defer child support and medical support at this time. We'll take that up at the status hearing. Your status hearing is going to be April the 3rd, 2025 at 10 a.m. April 3rd, 2025 at 10 a.m. Ms. Rendon, you have hired an attorney, so your conditional indigency finding has been removed. Mr. Trevino, do you have the ability to afford an attorney in this case?
No, I don't.
All right, you don't have anything you could sell or liquidate that would allow you to pay for an attorney?
No. I'm just gonna speak on my behalf and, because there's a lot of, that I gotta say.
Well,
And,
we don't need to get into all that right now. I'm just, you're telling me you can't afford an attorney.
no, I can't.
Okay, all right. I'm gonna maintain your indigency status and maintain Ms. Acevedo as your appointed attorney in this case. Ms. Rendon, I'm gonna keep you muted just to cut down on that noise. I need you both to listen to what I'm about to tell you. This case has now begun. The state of Texas took temporary managing conservatorship on an emergency basis based on my order on March the 4th, 2025. The state of Texas gives parents in child welfare cases 1 year, 12 months to demonstrate that you can provide a safe, stable, violence and drug-free home for your child. That year began on March the 4th. That year is going to end on March the 9th, 2026. Okay. The case does not have to last that long. It can go a lot faster, but it all depends on what the two of you decide to do. You're going to have your family group conference and your attorneys are going to help you figure out what we call a family plan of service. That family plan of service, after you create it with the help of your attorneys at your family group conference, they're going to ask me to make that an order of the court. And when I make it an order of the court on April the 3rd, when we come back, then you have to comply by that order in order to demonstrate that you're ready to have a reunification with your children. So stay in touch with your attorneys, stay in touch with your caseworker. When you get your caseworker right now, it's Miss Jones that you're working with, but you're going to get another permanency specialist between now and the next hearing who's going to work with you. Okay. And make sure that you stay in touch with the attorney ad litem for the children. That's Miss Harris. And make sure that you stay in touch with your own attorneys and that you get the information that you need. All right, so I think I've covered everything. Miss Thompson, is there anything I failed to address?
No, Your Honor.
All right. Well, thank you all for your time and your service. Thank you for working this out. We're off to a good start. Just make sure that you can get that family group conference and that you really participated in that, mom and dad, and get some good services that are going to help you so we can get through this case. I'll see you all back April the 3rd, 2025 at 10 a.m. Mr. Padilla, thank you for being here. Nice to meet you. And if nothing further, all parties are excused.
Could I get your name, Judge? I didn't write it down.
It's Robert Falkenberg.
Okay.
Judge Falkenberg.
Thank you, Judge.
Roxanne Carter is going to be the permanency specialist that's going to be contacting you, Mr. Trevino and Ms. Rendon. Okay, Roxanne Carter. All right, thank you all. All parties are excused.